Well, good evening, everybody. Welcome to our 2025 Fall Education event. We are so glad you've joined us tonight, whether it's in person or those tuning in via Zoom across the country tonight. My name is Andrew Olvested. I'm a wealth advisor, a husband, a father, and a coach. 2 years ago, I actually missed this very same event, our fall event, because our youngest son decided to arrive 2 months early. I'm happy to report that he's doing great now, though he's got plenty of attitude, gets into everything, does not sleep, and somehow managed to catch his 4-year-old brother in weight. So, all good things. But we're thrilled to have you here for a time of learning and a time of fellowship. Joining me on stage is such a genuine group of people, Gordon Wallman and Jill Molnar from Cornerstone Financial Solutions, along with Jana Voss and Bobby Turry from Legacy Law Firm. To kick us off, I'd love for each of you to share just a little bit, take 30 seconds to share about yourself personally and your role at your workplace. And we'll start with Bobby on the end.
Thank you. So I'm Bobby Turry. I'm a co-founder with my partner Jana at Legacy Law Firm. So I'm an attorney there. Kind of background. So I'm a board certified estate planning law specialist and a board certified elder law attorney. Practice in the areas of estate planning, asset protection planning, elder law, and then business planning. As far as family, I'm married to my high school sweetheart, and I tell him that we're going to stay happily married. So we'll see, but hopefully that continues. And then I also have 4 children, and they keep me on my toes. So, and then I have a Newfoundland, so I understand that fur baby because he's 172 pounds and a lot of fur.
Awesome. Jana?
And I'm Jana Voss. So as Bobby said, we started Legacy Law Firm. It's about 9.5 years now. I'm the old one at the office, and we have a great team, and we focus on estate planning, business planning, and elder law planning. I'm also married to my high school sweetheart, so we have that in common as well. And I have 3 grown daughters and a grandson who's about ready to turn a year. So glad to be here tonight and with this wonderful group of people to talk about a topic that's near and dear to our hearts.
Thank you, Jana. Jill?
Hello, everyone. My name is Jill Molnar. I am a wealth advisor and the branch operations manager for Cornerstone Financial Solutions. Not my only title, I am wife to my husband, George, and we have 2 daughters. So mom to Haley, who is in 8th grade, and Aubrey, who is in 4th grade. And like Bobby said, they keep us on our toes.
Gordon?
Well, good evening, everybody, and thank you for coming. What a great crowd we have here this evening. And so for those that don't know me, Gordon Wallman, as previously mentioned, I'm founder of Cornerstone about 33 years ago. So I think back, wow, how the fast the years have gone by, and some of you I've known for more than 25 years. So thank you for placing your trust in Cornerstone. So I have a great team here, and we have a lot of great people we're working with, and I have my lovely wife here, Sheila, if you wouldn't mind standing just for a minute, please. And so we've been married for about 23 years now, and 2 children and 8 grandchildren, and so we're excited to have you here tonight. So thank you for coming.
Yeah. As last part of our introduction here, every week our departments at Cornerstone meet as a department for planning and just to address headlines and things like that. And every week we start the meeting with sharing our personal best from the last week. So we'll keep that tradition going here, but I'll extend it out a little bit and ask our panel, give us your personal best from 2025 so far. Bobby gets to start.
I sat at the wrong location. So my personal best was, and I've visited with Gordon before on this, is trying to live a little bit more intentionally. Life can pass so fast, and I think as estate planners, we are keenly aware of how precious our time is. And so that is something that, and I have a great partner here who helped me be able to make sure I'm living my priorities and creating that living legacy that I want. So spending more time with family is my big thing that I was able to prioritize.
That's awesome. Thank you, Bobby. Gina, personal best.
Well, so at the beginning of the year, everyone at our firm chose a word for their word of the year. And I chose the word reflect because sometimes we all get so busy in the hustle and bustle of life that we forget to sit back and reflect and think what's truly important and how much we have to be thankful for. And that maybe sounds a little contrite, but it truly is the case, and we see it every day with the people we work with. So Bobby and I are both trying to be our accountability partners and making sure that we do live life and make sure we keep in mind what's important.
Awesome. Jill, personal best from 2025 so far.
So typically during the weeks when we go through all of the personal bests, I always say something about my girls, like it's an activity or something that I'm super proud. And so I tried really hard to think of something that was just mine. Not that my girls aren't important by any means, but so I came up with, I have a group of about 4 girlfriends from high school that we've remained really close. 2 of them have moved away, one's in Florida and one's in Arizona. And typically they always come back at some point during the year to visit family, but very rarely do they come back at the exact same times. And this year, they were back at the exact same time, and another friend of mine who still lives in the area were all able to get together for an extended period to reconnect. And so we had a little mini high school reunion with just kind of us 4 best friends.
Gordon, same question.
Well, I grew up on a farm, so I knew all about working, but over the years I've evolved where I try to become very intentional about having some things other than work, and a lot of that has to do with travel. So I've really enjoyed traveling with my wife Sheila, but not just my wife Sheila, but for some of you, we've put together some travel packages, and then what I'm looking forward to, in a couple of weeks we have some travel packages, and some of you I'm going to be traveling with to Croatia, etc. We're excited about that. And so it's just making time to do some of these things. And all work, no play is not so good either. So,
all right. Well, now on to what you're here to talk about tonight. For the next 5 hours, our panel is going to bring you some of the best insights and strategies when it comes to estate planning, and it will be in presidential debate format. But all jokes aside, we did have a lot of you submit a bunch of great questions in advance for tonight, and so we'll do our best to kind of cover as much as we can with the time we have. To keep us on track, I'll kind of be directing each question to just 1 or 2 of the panelists at a time. And so we wanted to start out with some of the basics early on. Estate planning is a very specialized field. Jana, when people think of attorneys, they often think of criminal law, divorce, or business attorneys. What makes an estate planning attorney different, and where do you guys find your niche?
And we don't do any of that, just so you know. You might see general practitioners, general lawyers that still do simple wills and some basic estate planning, but a more specialized estate planner, they do this every day. They live, eat, and breathe trusts and wills and probate and taxes and protection of your family. So if you're looking for a comprehensive plan, then you're going to want to see someone who does this day in and day out. And we often like to compare it to if you had a heart issue, you probably wouldn't go to your general practitioner to have them do heart surgery. You would visit a surgeon, a heart specialist, that would do the surgery. And that's how it is with estate planning, that it's become more and more complex. We see a lot of different issues nowadays with protection of family and of assets. And you're going to want to go to someone who does this every day if that's what you're looking for.
At Cornerstone, we believe estate planning isn't just for the wealthy. It's important for everyone, no matter family situation or estate size. So let's get a little practical here. Jill, what are the essential documents that everyone should have in place? Or maybe I'll put it another way, what steps should be taken today to make things easier for a family in the future?
Sure. So the first thing that everyone should have is a will. Even in the most basic of cases, we always say a will is super important. So a will outlines who is going to receive your assets. It can designate for those with minor children also who you want to be the guardian. So if you do not have a will, the states or the court decides. And they could decide how you would want it to be, or they could not. And so really, why leave that to chance? And then the second item would be a power of attorney, both for healthcare and finances. It can be the same person for both. It can be different, so that's completely up to you. But a power of attorney is a document that really lets you name someone that you trust to designate decisions either to do with financial matters or healthcare if you are unable to make those decisions yourself. And then lastly, at a bare minimum, we would say to have a living will or advance directive. And that just really lays out your wishes for your end of life care. And so really it allows where your loved ones are not left guessing what you would want to have happen. So it's just important for you to be able to make that decision and not the state, and making sure that you're making good decisions for healthcare and finances.
Yeah, Jana, I'll piggyback off Jill's points here and circle back to you. We often think the estate, we think of the big items or retirement accounts or house or whatever, but in reality, everything comes into play, whether it's big or small. And so thinking about things like, okay, furniture or vehicles or things like that, is there an easy way for some of that to kind of get included in an estate plan?
So in South Dakota, you can do what's called a separate personal property memorandum. So if you do have some family household items, heirlooms, antiques, and you want that to go to someone, your will might have a general clause that your kids share those items, but the property memorandum is also used for specific items. That's a really great way to leave those types of items because you can do that yourself. It just has to be signed and dated. You don't have to go see an attorney to add to that list or to subtract from it. So once again, having a comprehensive estate plan, you'll want to make sure that all of these things work together.
Awesome. Jane, I'll stick with you here. I apologize. See, Bobby, not so bad. Jana's got a few questions here, but a lot of people might come up with their initial documents and tuck it away, never think about it again. But life changes, families grow, different situations arise. So what advice would you give? How often should documents like Jill told us about, how often should those be reviewed, updated, and made sure they're relevant?
We like to have our clients come in at least every 3 years to review documents, or if they have some major life event, maybe someone named under the will has passed on, or they've had a birth in the family, or their wealth has changed significantly. So really any major life event. Also, if you move to another state, we always recommend that you go to an attorney who's licensed in that state to make sure that your documents are still going to be fitting your needs. And it's really up to the individual because, as we know, every family is different. So some come in, I have some clients that like to come in once a year and talk about things, and some that don't like to do the 3-year reviews and they wait till longer. But it's always a good idea to pull those documents out, blow off the dust, and take a look at them from time to time to make sure they're still doing what you want them to do.
Thank you, Jana. Bobby, can you expand a little bit on Jill's comment about what happens to someone if they die without an estate plan or die without those documents? In South Dakota specifically, but how does that compare to other states maybe? And then what are some problems that people run into?
So if you would pass away and you do not have a will and you have assets, what I call stuck in your name, meaning it didn't have a beneficiary designation or it didn't pass to a surviving joint owner by joint tenancy. And in South Dakota, the threshold for those assets that are in your name, if you have $100,000 or more in value of those assets, for personal property, right? So bank accounts, everything really that adds up that got stuck in your name at time of death, that would throw you into probate in South Dakota. On the real estate side, the threshold is $50,000 or higher of real estate. So say you pass away and your home is valued at $60,000 and you didn't have a transfer on death deed designation for that to go right to a beneficiary, then that home, right, or other assets would be subject to that probate. And it is state law and testacy law. So the state, you're under the state's estate plan if you don't have a will, and that is going to dictate how assets go. So it's really important to make sure that your wishes are honored, right, by doing your own will versus relying on what the government's going to dictate. And then for other states, so if you have, say a lake home in Minnesota, then that home would be subject to Minnesota laws. So Minnesota is different on the probate side than South Dakota, as is every state. So if you have assets in other states, know that you could actually have more than one probate that your family and loved ones are going through. So, and each state has their own tax laws and other implications. Minnesota has a $3 million estate tax exemption there for their state estate tax. So it is really important when we're looking at what are other state laws, what is probate. All of this can be avoided by doing good estate planning, avoiding probate, and making sure you're doing good tax planning.
Awesome. Gordon, from the outside looking in, based on what we've heard, it seems like that estate plan, having a will, super important. But I can imagine a lot of folks here thinking, wouldn't it just be easier to add my kids on to my house title or my checking account or even my investment accounts now and avoid the hassle later? Is that the best approach?
This is why it becomes very, very important to deal with specialists. So even today, I saw this, so where clients are trying to avoid probate issues, and so they put their children's names on their assets. So we have to take a look at all kinds of considerations. Number one, if you actually put your children's name on, as part owner, well, we have the gift tax rules to be concerned about. Most people don't think about that. But even more concerning than that, what I would have a concern about, and I just addressed this today with somebody who came to the office, but let's say that you put your children's name on as part owner of an account, trying to avoid the probate, make things simple, etc. Now let's say one of your children goes through a divorce, and the divorce attorney finds out about this. Is it possible now that your son-in-law gets those assets? All except yours, of course. Or is it possible one of your children could go into a financial transaction that didn't turn out so good? They might be very savvy, but let's say they're even a physician, that might be subject to a lot of lawsuits and that type of thing. And that attorney finds out about that. You have to be very, very careful about adding children's names. Transfer on death is an entirely different issue if you become upon your demise. But while you're living, you better be concerned about the size of the transaction, whether we're dealing with a gift tax rule, whether we're putting all of your assets at risk, whether it's, large accounts, your house, etc. Ultimately, these assets are supposed to protect you for the rest of your life from running out of money. And the last thing you want is to lose the assets. You have to be very, very careful about this. Very, very important to be dealing with people that understand the law concerning this.
Well, you made a good point. It's completely different than adding transfer on death or beneficiaries, which are extremely important too. And we'll add the comment of beneficiaries, transfer on death designations, that would trump the will, that would come first. And so having those beneficiaries is entirely different than adding a name on to the existing asset. Bobby, when people update their estate plans, it's not just about their children, it could be in-laws, stepchildren, or blended family members. And how do you help guide clients in choosing beneficiaries to ensure their wishes are respected while trying to avoid maybe some unintended consequences that come along with some of that?
Right. It's a lot of times there's a lot of family dynamics that people are facing. or goals that they want to see happen. Maybe it's with helping grandchildren with education or charitable intentions. So on some of those things, it's important to, if you're having any charitable intentions, it is a wonderful opportunity to use those retirement accounts to fund that at time of death. When you use a retirement account, the charity, if you're designating a portion of that, right, the charity is going to get that tax-free. Versus if you left that retirement to a child, the child would have to pay income taxes on it, right? So it's always better to leave to a charity from before tax dollars out of retirement versus after tax dollars that you could leave to family members and then they're paying less taxes. Same way with family, especially in a blended family situation, it's really important to make sure however you want to take care of your new spouse and yet make sure your kids are also protected and taken care of. One of the things that we deal with a lot is if a spouse suddenly passes away and then the surviving spouse gets remarried. A lot of times we'll see big retirement accounts, and how do you make sure that that's going to be protected for your kids, that you helped and built this over maybe a lifetime of marriage that you want to make sure is going to your children. So there's factors like that come into play. And then of course, family dynamics. Some children, aren't great at money management, and you have to call a spade a spade. Sometimes you protect children from themselves by how you might structure it with a trust. And sometimes, Gordon, you brought up the perfect example. Really, if you look at the chance of a child to go through divorce, that's basically a flip of a coin, right? About a 50% chance. And so we're dealing, helping a lot of parents try to navigate that. If you want to protect, for that child, you want that, retirement account or maybe investment account, your home, whatever it might be that you want to pass to a child, rather than just leaving that child name as a beneficiary, right? Maybe you leave that child with an inheritance protection trust, and now the beneficiary is a trust and not the child's name, so that it can stay protected in case they go through a divorce. So it's just really critical to think through tax planning, through family planning, right? And it's always great to try to keep things as simple as you can, but that meet your goals. And sometimes that might mean adding an inheritance protection trust. But you always have to make sure whatever estate planning you're doing, you're connecting the dots. And quite frankly, that's where we see a lot of plans go awry, because they don't have an advisor like you guys, or they don't have someone that's invested in making sure that their hard-earned dollars, right, is going to go where they want, and a beneficiary gets missed, it doesn't get filled out, maybe it's an ex-spouse, all of those types of things. So you also have to blow off the dust on your beneficiary designations and make sure it's going the way you want it to.
Yeah, awesome. Thank you, Bobby. Jana, you kind of made a comment earlier, so I'll circle back to you on this regard. If somebody needs to make a change with their beneficiaries, well, on the Cornerstone side, that can be done in their accounts, etc. But on your side, is there a simple, inexpensive way to change beneficiaries in an existing plan, or what are some advantages and disadvantages to that approach?
There are many things that every one of you in this room can do to make things easy for your family without having to come and see a lawyer. So that's by staying organized, keeping your documents together, having beneficiaries named. You don't need to use us to add beneficiaries to accounts or insurance policies or retirement accounts. You can do that yourself. You ask for the form and you fill it out. However, if you are going to make a change to a legal document, it is best to come back to the attorney. If you've already done estate planning and you have documents in place, it's generally pretty easy to make changes to those documents. And so you can do what's called a holographic will in South Dakota, which means that's your own will, that's a handwritten will. But let me tell you, we see those get challenged all the time because people don't follow the rules on those, or they don't have witnesses or a notary, so they're much more susceptible to challenge, either for incapacity or undue influence, or just because the execution wasn't done properly. So if you're making a change to a legal document, I know that probably going to your lawyer's office is the last thing you'd like to do, but let me tell you, it's worth it in the end.
I'll stay with you, Jana, in terms of what if somebody has done their estate plan, but maybe with an attorney that is no longer in business or retired, or their company is just non-existent. How do you guide clients through that?
That's a great question. So most, if an attorney goes out of business, then they should, if they have your original documents, they should be returning those to you, or they should have a successor. So a new attorney comes in and takes over the practice. But you're not tied to that attorney. So if your attorney leaves, you certainly can take your documents to another attorney. If an advisor sends us clients that want to review documents, we do that complimentary. So if Gordon or Jill sends someone to us, we would do that. And we'll give you an honest answer whether we think you need to refresh or whether they're good the way they are. But just remember, you're in charge of your own documents, your own file, and you can take it to whatever attorney you want to.
As we transition into kind of session 2 or segment 2 tonight, more dealing with some specific strategies that we've already slightly addressed, but they may or may not apply to each person in here. Each situation is unique. What's right for you may not be right for another person. But up to this point, we've talked about wills and we've talked about beneficiary designations. 2 of the biggest misconceptions that we hear in our office would be, number 1, I have a will and that should be enough. And number 2, everyone needs a trust. And that's not always the case, and it can cause a lot of confusion for clients walking through our door. So let's dig into that topic, the topic of trusts, a little bit more. And Bobby already mentioned some specific types of trusts like inherited trust, etc. But Jill, the most common that many people are familiar with and most common that we work with would be a revocable trust. So I have a couple questions for you. Number 1, what is the purpose of a revocable living trust? And how does it differ in purpose from a will?
Yeah, so a revocable living trust has a number of different reasons you would have it. One would be to avoid probate. Keep things private if you don't want things to be public. So if you go through probate, it is public record. So people could, if they wanted to, dig a little bit and find out more about your situation. A revocable living trust also makes it more easy if you would become incapacitated, just to manage assets and things. So a trust becomes effective when you pass, or not a trust, a will becomes effective when you pass away. A trust can be used while you're alive and after you're deceased.
Does naming your assets or putting your assets in a revocable trust provide any tax advantages, generally speaking?
No.
Okay. How does somebody know when they need a trust?
So not everyone needs a trust. Some examples would be, I think, Bobby, you had mentioned multiple properties in different states. So having a trust for a situation like that. If you wanted to avoid probate. Another reason would be, and now I can't remember if it was you, Jana, or Bobby, had talked about kids. And so I kind of explain it as a trust allows you to control things from the grave. And so if you wanted to put stipulations on your assets, specifically, if you had kids or grandkids that could potentially inherit money, and let's say they're 18, 19, 20 years old, 25, and you maybe have some concerns about them inheriting money at that age and making responsible decisions, you can put stipulations inside your trust as to a percentage or a dollar amount or however you name it. So, whoever you're naming as a beneficiary then would inherit maybe 20% when they're 25, and then they get another 30% when they're 35. So you can do a lot of stipulations if you wanted to just have a little bit more control, because if you have a will, when it gets distributed, that's it. Like, you have no say, no control as to how they would spend it or, anything along those lines.
Does that trust help protect assets from being used for like nursing home costs or Medicaid eligibility?
So a revocable living trust does not. It's mainly used more about convenience and control, not for tax and protection uses.
Yeah, one of the biggest worries we hear from clients nowadays is what happens if I end up in a nursing home? Will it wipe out everything I've worked hard for? Asset protection's become a major concern, probably for all of you. Gordon, we know from Jill that the revocable trust does not protect the assets from a nursing home standpoint. So what strategies do you kind of look at when this topic comes up, and how do you handle those client conversations?
Well, the first thing is we say to spend all your money before you die, right? So we don't have this issue, but now in reality, here's what, there's a difference of opinion amongst all of you. Even if I would ask you, what's your goal upon your demise? Some people would say, I've heard this quite often from some of you, the last day that I live, I want to spend my last dollar. And it's all about lifestyle. And so as financial planners, we're very much into lifestyle, living a good life with your hard-earned money and seeing you enjoy, your hard work, etc. But all things being equal, most of you are going to say that even if you want to spend your last dollar, whatever's left, you'd rather have go to your children, if you have children, or relatives versus, Uncle Sam or anybody else. So, many of you in this room, you can self-insure. So, we do these cash flow analysis. So, if we know that the nursing home cost, let's say as an example, is $10,000 a month, that's example only, and there's two of you, and times two, $20,000 a month, many of you can, in this room, you can afford to self-insure if you want to. So you don't necessarily need, all the techniques that we're talking about. However, some of you in the room, are going to be very concerned about leaving the maximum amount that you can to your children, relatives, and some of you can't afford to self-insure. Some of you have good nursing home insurance policies, and that can provide adequate protection. There's various different types that are out there. Some of you in the room maybe would like to have it, you can't get it because of your health. And so that's an issue. For some of you in the room that, maybe can't afford to self-insure, can't get long-term care insurance, there's different types of asset protection strategies that are available. But most of those, you have to implement to be real effective probably 5 years, ahead of time. So it's not like you do this the last day of your life. If we think about if you're trying to get on Medicaid, some of the benefits, etc., as an example, that's designed for those people that are poor. And of course, there used to be a 3-year look back, and now it's 5-year look back. So these strategies take some time. But this is an area that's very confusing. So how we do it at Cornerstone is first we take a look at, the risks that you have. Some of you can self-insure, some of you can't. Some of you are willing to take the risk, some of you are not. Some of you have long-term care insurance. That's a Cadillac, some of it covers part of it. Some don't have long-term care insurance and, hate paying insurance premiums. I too hate paying insurance premiums if I don't have to. And however, it's a risk decision. And so if it's important to you to leave a lot of assets to your children or family members, and even if you can self-insure, one thing I appreciate about legacy law, they got all these advanced asset protection strategies, and they're very, very good at it for those of you that are interested in that. So everybody's situation is different. And what you can't do very well is give away like IRA assets and those type of things without creating huge gifts. So we have to think through these things carefully.
Bobby, I'll turn over to you on the same topic here and piggybacking off of some of the things Gordon mentioned, but we talk about how quickly a nursing home can drain assets. Many people in this room are on Medicare. So I ask you this question: what role does Medicare actually play when it comes to long-term care?
So Medicare is health insurance. It is not long-term care insurance. So the most that Medicare would ever pay out is up to 100 days. So oftentimes we might have a client that has a hospital stay because they fell and broke their hip. and then they're doing rehab maybe at a skilled nursing home facility, right? And Medicare will cover at most up to 100 days. They actually start staggering off that. So it is not long-term care insurance. The only type of government benefit that will cover long-term care is going to be Medicaid, unless you are a veteran that has a 70% or higher disability compensation rating, right? Disability related to service. So otherwise, Medicaid is the only government benefit that will help for purposes of covering long-term care costs.
Okay, so for the Medicaid planning then, going off of Gordon's, some advanced strategies, does South Dakota offer any unique advantages in this regard, Bobby?
Yes, so under federal law, you have the ability to do an irrevocable trust. It has to be set up right, in meaning that it has to meet with federal law requirements and then state law requirements. So here in South Dakota, as in every 50 other states, right, Minnesota was the last outlier. And then they actually had a case a couple years ago where the state was forced to recognize these irrevocable trusts. So now these types of asset protection trusts are called a Medicaid asset protection trust. They're recognized in all 50 states. So here in South Dakota, we have the ability to be able to shelter and protect assets right under this. Now, this is where I think financial planning and legal planning, right, asset protection planning, complement each other. So I can't, shelter assets and give someone cash flow, right? But that's what you guys, when you're working on that financial side, that you're able to help make sure people can really have that quality of life, that, lifestyle that they want. But what about the what ifs? So here in Sioux Falls, right, we see some assisted living facilities, they're charging $14,000 a month for one individual. And that's assisted living. I've got some clients that are in skilled level care that are they're getting charged $18,000 a month. For most of my clients that have both spouses in there, you're usually looking at minimum $21,000 a month. So these costs can be financially catastrophic. That's where making sure you're doing good financial planning, but also sometimes coupling that with legal strategies to do asset protection planning. And I know a lot of times with asset protection planning, people are thinking about leaving assets. We always like to back up. No, it's first about ensuring that you have your own dignity. When we do these types of plans, I have one spouse that she wanted to use the limited resources that they had to shelter it. And so we got the husband who was in a nursing home on Medicaid. We sheltered their investment so that they didn't have to keep spending down. And then what we did, because at that particular care home, he would have had to have been in a shared room. But she wants to go visit him every day. That's her husband. And she doesn't want to have to go and have a roommate in with him. And that's where that dignity comes from. So what she did was, with that sheltered resources, she said, okay, we'll have Medicaid pay the base rate for that room, but then I'll private pay the difference to keep him in a private room. So when I go visit my husband, it's just me and him. I don't have to have a roommate in there. But instead of paying 12 grand a month, she's only paying $2,000 a month. Well, that's a totally different financial ballgame. So this is, again, the importance of being able to strategize. When it comes to some of the unique laws in South Dakota has a trust called a special spousal trust. That's wonderful tax planning. You can do this with a revocable trust or an irrevocable trust. But let's just talk about an investment. So say when you put an investment in this type of trust, and you put in $100,000, and then it grows to $500,000. You have $400,000 of appreciation, right, that you'd otherwise pay capital gains tax on. When you use this type of trust, when we're doing that for elder law planning or estate planning, the beauty of this is that you're eliminating or greatly reducing capital gains taxes on that appreciated value. So that is, a unique trust that South Dakota has that other states don't. There's only a couple in the nation that has this. And what we find is most people don't even know about this to take advantage of it in our own backyard. So it is a wonderful tax planning tool that we often couple with these asset protection trusts, but it can be there. And then here in South Dakota, another unique factor is that we do have strategies that I've developed alongside with another elder law attorney who's specialized and a fantastic tax attorney, where we can do crisis planning and shelter assets without having to spend down and get around the 5 years. And this type of technique that we developed and have used is wonderful so that you don't have to sell off investments and get a capital gains tax incurrence. And there's other tools. So we live in a great state for trusts and estate planning, and there's a lot of things that folks, can take advantage of here in South Dakota.
Thank you.
Sorry I was so long.
No, that's great. Policy can impact the estate planning, to your point, Bobby. And so you've probably heard of some of the policies in the last few years that have come out of Washington, D.C. The Secure Act, the Secure Act 2.0, the Big Beautiful Bill. And so starting with the Secure Act, just kind of touch briefly, Jill, within the Secure Act, what does the 10-year rule mean for, not only for the account holder of like retirement accounts, but also beneficiaries?
Yeah, so the Secure Act, the 10-year rule, basically states that if non-spouses are beneficiary and they inherit IRAs or retirement accounts, that they have 10 years to spend that down to zero. So it really means, for account holders to just think about, it could change kind of the legacy planning that you want to do. So as an adult child, typically would be an example of a non-spouse. They will have 10 years instead of their lifetime to spend your IRA. So that was a big change that happened in 2020. And so at the year 10, the end of the year 10, that account has to be zero. So it can have some big tax implications. And so for the adult, the child that inherits, you have to be aware there's some flexibility as to when and how much you can take over those 10 years, but it could potentially put you into a higher tax bracket because you're required to spend that within 10 years. So ultimately, kind of simplified, it really increases the taxation of retirement accounts is what the 10-year rule did.
Also within the Secure Act, it added some complexity for naming a trust as beneficiary of an IRA. Jana, can you touch base? Why is naming a trust as beneficiary, why does that add such complexity?
Well, it doesn't really add complexity if you have the right type of trust. So the trust can be treated the same as an individual beneficiary. So if you've got retirement accounts, often we're suggesting you name the spouse first and then the kids if they're adults, or the trust if you want the inheritance protection. Because if you give it to your children outright, once again, it's theirs, and if they have creditors or divorce issues, the account could be gone. If you name the trust and the trust is drafted correctly, you can still get the 10-year payout, but if the child has a creditor issue, you can leave the funds in the trust. Jill's correct that the fund has to be paid out, but it can stay in the trust. Now, there are some disadvantages because the trusts get hit with top tax rates higher than an individual, but you might have a decision to make. What's better, that you give it to the child at a lower tax bracket, but then a creditor takes that money, or you leave it in the trust and pay a little higher tax, but then it can stay there for that child. So we commonly name trusts as beneficiaries of IRAs, but you have to be very careful and make sure the trust is drafted correctly so you can still get the 10-year payout.
Thank you, Jana. I'm going to skip ahead a little bit. For the sake of time, kind of wrap up with segment 3 here. We've covered a lot of technical and strategic aspects of estate planning. But as we wrap up, we want to turn to real practical dilemmas that families face. And so a common dilemma arises when one family member has maybe ongoing financial needs while a sibling has accumulated a lot of wealth, or maybe there's a situation where there's some kids that have distanced themselves from the family, or Maybe there's a married couple with kids on both sides of the family from previous marriages. So Jill, I'll start with you. What counsel, what considerations would you offer to someone maybe seeking to provide a fair but not necessarily equal inheritance to family members?
Yeah, so this question's hard because it's very personal, very situational. I think probably everyone in the room would have a different opinion on different things. And so when a client is dealing with a situation where they want it to be fair and not necessarily equal, we remind them that that is up to them. It's a you decision, and not everyone is going to agree, which I think is the really hard part. So some guidance that I have given during those cases is obviously that they need to feel very comfortable about the final decision they made. But as just a suggestion sometimes, because when all of those wishes are getting announced to the family and everything, unfortunately, you're not there in person, right? And so sometimes I say writing a letter, putting some things down on paper, just explaining your side, the thought process, why you decided that, just trying to be as transparent as possible. It might not still go over well, it might as well, but at least you have tried to explain your thought process during a situation like that.
Thank you. Bobby, I'm going to, it's kind of same question, if you will, but take it a different spin. Maybe on blended families a little bit, and fair and equal may not be the same, but how do you have that conversation with your clients?
I would echo the same thing. It's such a unique family situation where if that's what your heart is telling you to do, and blended family considerations, right? Sometimes we'll see different spouses bringing in different amounts of value, right? Maybe one was a big saver, maybe another one had a life issue, so they spent more on the retirement side, but they want to ensure that it's going to children. So just because they got remarried doesn't mean it's always going to be equal. And then I would just add too, sometimes we'll see children, especially on the aging side, maybe we'll have one child that is really helping, parents as they are aging in place or as a caregiver even. And so there's so many considerations, and you really just need to be intentional. Don't just have it happen by accident. And that's what we would encourage you guys to do is speak, especially on the beneficiary side with your financial advisor, and then us on the estate planning side.
Gordon, what is one of the biggest mistakes that you've seen in estate planning and on that side?
Well, there's a lot of mistakes that take place on the estate planning side, and oftentimes what's best for estate planning might not be what's best for income tax planning, but one of them is quite common. We deal with quite a few people that are involved with agriculture, and many of them own large parcels of land. Maybe there's land that you purchased, you pay $200 an acre for it, or you inherit it yourself at some time, and then maybe it's worth $12,000 an acre now. And in your estate plan, you got diagnosed with some terminal illness, etc., and you're concerned about, maybe the nursing home takes it, or you're concerned about just protection, period. So what's typical that I see take place is that people will transfer that land to their kids, gift it while they're living, etc., and completely miss out on the stepped up on cost basis. So upon your demise, maybe you paid $200 an acre for that land, now it's worth $12,000. Upon your demise, you get a step up on cost basis based on date of death, or alternative 6 months later. You could have had done proper planning, completely avoided any income taxes if there was a sale that eventually took place. So oftentimes what we'll take a look at, and we've coordinated some cases with legacy law where we found out that there was a terminal situation taking place, and even between a husband and a wife, and maybe it was even owned in joint name, and one particular member was about to die, put all the land in that person's name. We have to think through it all carefully, make sure there's other risks involved as well. But now upon that person's demise, get a complete step up on cost basis, and if they are interested in selling it, now completely avoid the income tax. So oftentimes, probably the biggest mistake I make is, or I see made, is by wrong ownership of the titles of the assets and gifting assets when they shouldn't be, and completely losing the stepped up on cost basis, whether it's securities, land, you name it.
Jana, what is one thing you wish that more people understood before they start estate planning? What's one thing you wish more people understood before they started their estate plan?
I think that one of the misconceptions we see every day is that people think they come in and if they have a will, that means they don't go through probate. And often they don't know what probate is, but they know they don't want to go through it. And it's not whether or not you have a will, it's how you own assets. And Bobby touched on this already. It's if you have assets in your sole name in South Dakota that are essentially over $100,000 with no co-owner or no beneficiary. So the will is irrelevant. It's how you own assets.
Thank you. Thank you. Last question here before we wrap up. Many people feel that their plan is set, but they're not sure what happens when they pass away. So, Jane, I'll start with you. Can you walk us through how a plan is carried out, both by Cornerstone and Legacy? How does financial advisor and estate attorneys best work together to ensure there's a coordinated effort to their plan?
And a good organized estate administration or trust administration really starts with you, because the more organized that you are and the more up-to-date your documents are, the easier it's going to be on the back end. So if you have to go through probate, then that's a court process. Jill mentioned that already. It's public record. It takes some time. It takes some expense. Anytime you have to go into court, that's an expense. If instead you have beneficiaries on everything, you avoid probate, or if you have a trust, there will still likely be some administration that needs to be done. But if you have a trust, you do the planning really on the front end, and so your family has it much easier on the back end. So it's really all up to you what you decide to do that's going to really drive how that administration is going to go. It's wonderful when you work with advisors that know you, like Gordon's team. I know he works so closely with you, and it makes our job a lot easier when you have a great advisor, because we know that the beneficiary designations are up to date and correct. We know that you've talked to them about potential tax consequences, about the long-term care planning and everything else that goes into the estate planning. And so when we work with folks from Cornerstone, the administration process usually goes smoother, which means you save money.
Gordon, wrap up with that same thought. Why is it that all of us at the table here and with both teams are striving for a coordinated effort for our clients?
Well, it takes, to really have a good team, to give you good guidance, we feel you need to have a good financial planner, a good attorney that specializes in what you're asking them to do. In this case, estate planning, make sure that they specialize in that, as Jana mentioned before. And then you should, for most of you should probably have a good CPA too. But what we find is that working with specialists is really important based on the problems that you're trying to solve. You know, Bobby, or I think it was Jana, gave a good example before about if you want heart surgery, you know, you don't go to a generalist typically. But I'm going to say a little bit too about another common mistake. A lot of people can spend enormous amounts of money on trusts and this type of thing, but if you don't transfer the assets to the trust, really don't mean much. And that's the thing I appreciate about legacy law. They'll follow up on all that type of thing. And so likewise, I find a lot of people, they're making wills, etc., but they never change the beneficiary. So we think about it. If your IRA says it goes to your daughter, your will says it goes to your son. Contract takes precedence over will. It makes no difference what your will says. It goes according to whatever your contract says. And so oftentimes we see they're conflicting. We don't think through these things. So the thing I appreciate about legacy law is if we work very closely with them, and their follow through is very, very good, and we coordinate things together. So typically if something were to happen to one of you, we have a family meeting, and unfortunately we've had too many of those. And typically we kind of act as the quarterback for, okay, go see your CPA on this, go see your attorney on this, and sort through the things that needs to be done. And if we're doing our job, we'll have a complete, financial balance sheet. And so we can go item by item, here's what you need to consider. But there's a lot involved with this, and there's a lot of room for mistakes. And there's a lot of room for mistakes on the administration part of it too. But we feel it's important for the financial planner, whoever you're working with, to be working with the attorney. If one person is trying to do it all on their own without coordinating with the other, there's room for a lot of mistakes. And when it comes time to dealing with money, my 33 years of experience has taught me, if there's room for Murphy to get in and create a problem and cause conflict in your family, it usually does. So we like to try eliminating Murphy up front as much as we possibly can.
As we conclude, we just want to take a moment, and the goal of today is just for you to take a moment to think about your future and the future you're creating for your family, your loved ones, your legacy. And it's more about a thoughtful, intentional process that ensures your wishes are carried out exactly as you'd like. And at Cornerstone, at Legacy, we're here to walk with you through every step of it. We'll collaborate closely and make sure everything gets taken care of. We want to challenge you to reflect on your own plan. Is it up to date? Do things need updated? Beneficiary designation, your wishes. Could small tweaks today prevent future headaches for your family? And finally, we hope today inspires more than just reflection. We hope it sparks some conversations with your family, with your friends, or maybe your colleagues. By doing so, you're not only protecting your own legacy, but helping others take control of theirs. Jory's going to come up here in just a minute. He's going to share a couple closing thoughts, one of which will be Ever Plans, and he's going to talk about that. We also have a physical copy of that as well. And my challenge to you when Jory comes up to discuss through that, my challenge to you is think deeply about your life and your legacy, and take the time to really go through this, and not just the accounts, not just your documents, but all the pieces that hold your world together. Maybe it's even things you haven't thought of. Talked to a client this morning. They part of their assets would be they have a lot of airline miles or credit card points, or your email and your cloud storage, your password manager, your social media login, your banking information. Store that in a safe place and decide who has access. A couple of focused hours now can save your family time and confusion down the road.
I have one really specific question. When I win the Powerball tomorrow night of $1.2 billion, can I see the four of you on Thursday morning?
Yes.
We'll all make ourselves available.
We will all be available, but only after 10 a.m. So,
By the way, that should alert everyone else in this room, don't buy a Powerball.
thank you. We'll see everybody Thursday
We
morning.
should add that you can also give $19,000 per person to everyone in this room if you'd like, with no tax consequences.
My spouse as well, and my 3 kids. So, our mission's simple: to leave a meaningful, lasting legacy that honors your values. Thank you to Bobby, Jana, and the entire Legacy Law team for their insights and their expertise. Thank you, Jill and Gordon, for your expertise tonight. We thank all of you for having us. Jory, while he makes his way up for some closing thoughts, I want all of you, let's give a big hand to our panelists tonight.